everybody. Again, my name is Jennifer Rennie. I'm the director of the National Child Welfare Resource Center on Legal and Judicial Issues. I'm one of the co-authors of the Child Safety Guide, and my illustrious colleague and co-author, Terry Roman, and also our consultant, Timothy Travis, who does most of our training and technical assistance on the Safety Guide. You'll hear from both of them in a moment. But just by way of background, our two resource centers are part of a broader technical assistance network funded by HHS, the Children's Bureau. So they fund us to go out and provide free training and technical assistance to the states. Also, we're funded to develop and create tools and instruments for the field, and that was the origins of this Child Safety Guide. As a co-author of the guide, I like to have my name on the cover there, but really to give credit where credit is due. I had the idea that we needed the guide. Terry lost her eyes when I go first, because she's going to tell you the guide was her idea. Maybe it was, but back in my infancy, when I first started out my career, not as a policy person, but as a frontline person representing children in abuse and neglect cases, I saw a need for such a guide because those of us in the legal field, and I mean all the attorney groups, so children's attorneys, parents' attorneys, attorneys representing child welfare agencies, and dare I say judges as well, really lacked what I thought was an understanding of specific criteria that goes into safety decision making. Now, what do I mean by safety decision making? Certainly and obviously the front end, so the removal decision. But equally as importantly, the back end and the reunification decision. So people look at the guide and think, oh, you know, CPS is about the front end. It's not that, but it's not just that. It's about assessing safety decisions throughout the life of the case. So as I was saying, when I started out as an attorney and had really no training on how these decisions are made or even what kind of information we would need to make such a decision, I saw the need for the guide. It wasn't until 8 years later when I went to the ADA that I started in conversations about what would it take really to write such a thing. And so you'll hear, as I said, from my co-author, Terry Roman, who's been in the field of child welfare a number of years working on implementing the principles that you see in the guide in the child welfare agencies. So it's a partnership between child welfare agencies and the legal community. And we wrote the guide. It was published. It took actually quite a while to write. It went through several editorial revisions. A lot of it was cutting down on the length of the guide so that it would be more pithy, user-friendly, something that judges and lawyers were actually going to read instead of a 300-page treatise on child safety. So what you have in front of you is the final product. And we began, shortly after the guide was published, providing training and technical assistance on the guide. That's really what we're going to talk about today. I think I was somewhat naive when we started, and I thought that if people came to a 2-hour session and learned what was in the guide, and learn how to use the tools in the guide and understand the concepts of the guide, that they would then take it out and that would improve practice and they would start representing their clients, and if they were a judge, they would start making decisions, asking more provocative, relevant, probing questions of the lawyers, of the social workers, and lo and behold, so I'm not going to say that didn't happen at all, it did, but it really wasn't implementation. And so we really worked as a team, primarily the three of us that you see here work as a team to talk about, well, what is true implementation? And Timothy, who's going to come up in a minute, is going to distinguish between training and real meaningful implementation. And then we have invited, as panelists, a team from Florida and a team from Virginia, which it would really, really bring tears to your eyes of inspiration of how amazing these two jurisdictions have been with regard to implementation of the Safety Guide. So as you hear from them, you will realize that implementation is a true partnership. So I wish that as a resource center, paid for by someone else, I could come into your state and wave my magic wand, and all the legal people and the child welfare people would be on the same page and understand all this. and then that would improve practice, and it doesn't work that way. And what's really required is some commitment, integrity, and work on the part of the state. So you'll hear from the panelists in terms of what spoke to them about the safety guide, like why was this worth their valuable time, and what did they do, and how did they do it? So I'm now going to invite Timothy up to say a little bit more in detail about this distinction between training and technical assistance and some of the ideas with regard to how we went about implementing the safety guide. Thank you.
Thank you, Jennifer. I really don't do my best work at a podium, so excuse me. My name is Timothy Travis. I am a consultant with the National Resource Center on Legal and Judicial Issues. I am an attorney. I represent children and families, parents and kids. I've been a lawyer for kids. I've been a CASA. I've prosecuted terminations. I've sat in every seat in the courtroom except that of the child welfare worker. I've been a circuit court judge as well. And I, like Jen, I wish that I'd had the safety guide back in the day. But what I want to talk to you about today is a little bit of context, because you're going to hear these people talking about how they're implementing the safety guide in their jurisdiction, and there is a context to put around this. The Children's Bureau wants the people who go out to the states and do the TA to move away from training, where if somebody stands up, some certified smart person stands up in front of the room, talks to everybody, and then gets on a plane and goes home, wondering whether anybody heard anything that was said and if it will make any difference in practice. And what the Children's Bureau has said to us is, we want you to work with people doing implementation projects. So our resource center has a model for implementation that we developed at a meeting, and it goes like this. In doing implementation projects, we want to work with local people in local jurisdictions. And we want to have a group of people in that local jurisdiction who are committed to the project that we're working on. And they need to be people in all the domains of the system relevant to this project, all the people who need to make it go, who are in a position to make it go. And it doesn't have to be the leader of the child welfare agency or the chief judge, but it needs to be people, champions, if you will, throughout the domain, an inclusive, collaborative, relatively small group. And we want those people to either be part of an existing group, because there are model courts and other existing groups already, we can work through those. And if there isn't one, we need to create an ad hoc group. And what we also need is for them to know that they are responsible for creating a plan, which means goals, it means action steps, it means benchmarks, it means a process for evaluation with the expectation that we're going to evaluate periodically, and then in light of what we find out about through the evaluation, we're going to reboot and we're going to move on and keep going on implementing. We also would like to see state-level support. We would like to see the court improvement projects in the state and the state child welfare agencies also involved in supporting these local projects, because we're not talking about doing a whole state, we're talking about Hampton, Virginia, we're talking about Fort Myers in Florida. Now, what happens is, if you decide that you would like to have your community look at implementing the Child Safety Guide, here's what we do. You talk to us on the phone, and we lay out some ideas, and we talk to you about things, but essentially what we're going to do is we're going to want to come to your community, we're going to want to talk to that relatively small group of people who are influential in the important domains of your child welfare system. And what we're going to do is we're going to give an extended overview, like about 3+ hours of overview. You saw the overview yesterday, you ain't seen nothing yet. We're going to be in your community for a day. After we do this overview, we're going to do some hands-on kind of work, seat work, small groups, using the principles of the guide, applying them to fact patterns just to get you used to it. And then we're going to have a discussion about implementation. When you see the barriers, strengths, how do you see yourself doing this? Then we're going to go away. And that local group of yours is going to decide, do you really want to go forward with this? And if you decide that you're going to go forward with this, if that group decides, then we're going to come back and we're going to work with that group for 2 days maybe about implementation and supporting your group in making its own plan to implement whatever piece of the guide you want to start with, okay? And we're going to want to see action plans, we're going to want to see benchmarks, we're going to want to see evaluation processes, and an idea about rebooting in light of what we see. And then we're going to go away again once you have your plan, and you're going to implement your plan. And then we're going to come back in a period of time, it's already been decided upon, and we're going to look at your evaluation. And we're going to do things like look through your files, we're going to do things like focus groups as we've done in Fort Myers, and then we're going to sit down in an exit interview kind of mode with your group and discuss the evaluation and discuss the idea of how we can support your rebooting in light of what you've learned to get to where you want to go. Okay? And then the group is going to make new strategies, new action plans, etc., go through that, and then we're going to go away again, and then we're going to come back in a certain period of time, and we're going to do it all over again. Now, while we're gone, we're available to consult on the phone or whatever. But the important thing to remember here is this is local work done by local people. We are not coming in to spray and pray that you are going to get what you need. You are not the passive recipients of what we're trying to do here. You are the active people. Did I mention this is free? Okay? You don't pay us anything to come. Our resource center pays us. This is hard work, as I said, it's done in your community. What you get out of this is not only whatever benefit is going to accrue to you from your work with the safety guide. What's really important is that you are developing in your community a durable local infrastructure of change. Through the relationships that are created with this group that we're working with, you're creating a process, protocols in your community that you can do any reform project you want to. PIP says you got to do this, you can plug it into this group. Legislature has some bright idea about some great thing that you need to do next, you can plug it into this group, and you can implement that. You can even implement ideas that you think are a good idea. The Child Safety Guide says that we want to move away from a compliance-driven practice. We want to move away from saying, Mom did this, Mom did that, Mom did the other thing. And we want to move toward describing what Mom and Dad have to do to change so that they can develop the capacity to protect their own children. And then we want to support them changing in the ways that we describe. What our change model wants to do for local communities and child welfare communities is exactly the same thing. We don't want to tell you some bunch of great ideas and leave you. What we want to do is we want to help you identify the ways you want your system to function differently. And then we want to support and encourage you in making those changes in your community. 15 years from now, you will probably have forgotten about the Child Safety Guide. But if you successfully do these kinds of projects, you're going to have built something far more important, and that is that infrastructure to do change in your local community. What you're going to hear from the teams here today is going to make sense to you, I hope, within the context of what I just talked about. And now, Terry Rowland, would you like to?
Yeah, I guess. I'm only going to take a couple minutes. Really, I think that what we wanted was hear the team here. But, good afternoon. I'm Terry Rowland, and I'm the Associate Director of the Resource Center for Child Protective Services, and Jen's co-authored the book. So, let me just say a couple things, and then I promise I'm going to turn this over to the folks who I think you want to hear more from. We're assuming by you coming today that in reading the description of this is that we obviously are not going over any of the content of the guide. So we're assuming that you are familiar with it, whether you came to our workshop where we went through it quite quickly yesterday, or you've read it or seen some other kind of presentation on it. Likely, if you're here, it's because this is interesting to you, and there may be only one or two ideas in the guide that are of interest to you. So in other words, we want to make sure that you understand that when we say implement the guide, that we're not suggesting that a jurisdiction has to take this guide and love every idea in it cover to cover and think that it needs to replace something you're doing now. Some of you may really like the way we're more precise about the difference between a safety plan and a case plan or a treatment plan. Some of you may really like the way we talk about case planning as being related to the very reason why the family's being served, namely that there's threats and there's a lack of protective capacity. Others really like the idea of conditions for return so that reunification happens sooner and children return home with an in-home safety plan. Regardless of what you like, we're probably going to ask you to examine first, before we start helping you craft safety plans in a better way, is to make sure that you understand the families you say you're wanting to help. So in other words, that first fundamental critical thinking piece, principle of having enough information in order to make a decision. I can't help you as a consultant know whether or not you're making good decisions about which children should be in the home, which children should be out of the home, if you don't have sufficient information to answer those 6 questions that we talk about in the beginning chapters of the guide. So when each of these communities talk to us about their enthusiasm about implementing ideas in the guide, we gave them that feedback of, if you believe you're collecting that information now, then let's examine that carefully. If you already feel in looking at this information that we're giving you about these 6 questions and what constitutes sufficient answers to these 6 questions, if you think in your hearts that we got a ways to go to improve this, and everybody's got a role in it. Judges should be asking better questions, parents' attorneys can be more prepared around relevant issues, agency attorneys can be prompting, and of course child welfare has the obligation to be out in the living room gathering this information. So then let's help you start at that point, get to some fidelity around information collection, and then let's move in the direction of what exactly do you like that is in this guide, and where do we begin in terms of where you really want to implement. We take that piece apart, and then we also apply, both Jen and Timothy have mentioned to you, we take the best of what we know from implementation science. And even if that's a term that isn't something that even is all that desirable of a term for you to use or think about what you've been successful in your own field in implementing anything. And you'd likely be able to see that there was leadership that articulated what is required and was tenacious about holding everyone accountable to meeting that kind of vision or expectation. That there was policy and procedure that laid out a way to operationalize that vision, that there was supervision that was expert and that was immediately devoted to giving the coaching and direction that needed to happen. There was forms and instructions and documentation requirements and an automation system that was consistent with what it is that you want. And then what Timothy's been talking about, where technical assistance is designed to keep coming back and looking. He used the word evaluation. I used the word, we're going to measure to see whether or not you've got fidelity to what it is. Are you doing what you say you want to do? We give you that feedback so you can correct your course, and we move again in the direction you want to go. So those are the pieces that we are trying to look at. When is a jurisdiction ready for which piece of technical assistance to help keep this not one organizational chart. So we're all sort of learning together of the herding of cats across these disciplines. How's everyone going to be moving in the same direction so that we're implementing with some fidelity? We're going to hear from Florida first, I think, and I think as you listen to these folks, I think you'll hear the pieces around leadership, around what people have been designing in order to prompt people to stay on the course, and what some of their struggles have been as well. So I'm going to turn it over to, I believe, Judge Clear. You guys are going to stay where you are and just pass the microphone? Is that going to work rather than you can do whatever you want? Is it? I think you got it.
Okay, this works. Good. I'm Beth Freer, and I'm a circuit court judge in Florida, in Collier County, which is on the west coast of Florida. I am assigned in the dependency division, and I've been there for about 2.5 years. Before I was a dependency judge, I was a family law attorney and did a little bit of work in criminal also. Before I sort of launch into our subject matter, I want to also introduce Karen Turcott.
Hi, good afternoon. My name is Karen Turcott. I am the Director of Staff Development and Training and the Education Liaison for Children's Network of Southwest Florida, which is the local community-based care agency that oversees all of child welfare, with the exception of investigations, which continues to be with the state.
I'm sort of interested before we start who we've got in the room. Are there attorneys and judges in the room? Oh, great. And then investigators and case managers? Who's everybody else? Great, okay. Okay, great, okay. Well, this is how we sort of started. I saw their presentation at a judges conference. I had just been assigned to the dependency division I've been in the felony division for a couple of years, and I had never practiced dependency law, so of course that's where they put me. And I started making decisions that I was really not comfortable making. I didn't have enough information. I wasn't getting enough evidence. The case managers weren't giving me enough information. And I didn't know whether I was making the right decisions. And it's a scary thing because we're dealing with kids' lives. So when I saw this presentation, I went, that's it. In family law in Florida, there are 105 different factors that you have to look at and make findings on in terms of all the various relief that is offered when you're getting divorced. There is nothing in dependency. There's abuse, neglect, and abandonment, and some vague definitions. You might get a little bit more specific when you look at what the definition of harm is, but that's it. And so this model said to me, here are the basic criteria that define these situations. And so that's the first thing that I saw as a possibility with this model, was to give me the findings, to give me a guide in terms of what evidence I was looking for, what findings I needed to make, and to make better decisions. So that's sort of how it started with us.
I would definitely echo what Judge Kerr said, and it's interesting because when you first start looking through the guide and you get excited about something new and different, there's a few things that really stand out for me, as well as for our agency, in that we're really looking at, are kids sleeping in the right beds tonight? And we know that sometimes they are and sometimes they're not. And can children go home? So rather than being incident-driven, this really takes a holistic approach of not just what's the maltreatment today on the family's worst day, but really what does that family look like in collection of all of their strengths and their needs together. So it really forces each of our case managers and our investigators at each opportunity when they engage with the family to think about, have they done enough? Is it safe enough for the kids to go home? So it really challenges your thinking of, instead of going down the rabbit hole of we're dealing with a maltreatment, it really takes into consideration the whole family and thinking about each opportunity. If I came to your door today for the first time, would I remove or not? Would I separate that child from you? Have you done enough? And if the answer is no, I wouldn't separate that child today, then we need to change focus of how do we get those kids back home. If they're in out-of-home care, how do we expedite that process safely and move from out-of-home care to in-home care with supports? So that was kind of the aha moment for us, and we were really excited about that premise in being able to reunify children sooner and really take a close look at were we separating children from their families unnecessarily, and were we leaving children in unsafe situations. So we got together and we did all kinds of training and got everybody excited about it, but really for the implementation pieces of it, what was critical for us was that it needed to be leadership driven. You have got to have the top echelons of each of your primary agencies on board with this, championing this cause. And everybody pretty much knows that, but you really have to live that. Otherwise, it gets lost in the minutia of casework and everything that everybody's doing every day. So leadership driven absolutely has to be there at the very top. Additionally, like Tim said, and Terry and Jen, everybody's really talking about the opportunities to continually reassess. Where are you? What are your action steps? What's the next step? Holding each other accountable, and having that multidisciplinary approach of the guardian ad litems and investigations and the judges and your community providers and each stakeholder really coming to the table and deciding what is it that they're going to do to move this forward. Establishing those benchmarks. One thing that was critical for us, and if you're contemplating doing this back in your own areas, is really sitting down and figuring out what are those critical junctures that we can apply these concepts to. Because we all know them. We know they're at case transfer, we know they're at reunification, we know they're at judicial review and family assessments, and all of those critical pieces that we're doing those real clear assessments, we need to be incorporating this as a foundation of our safety decision framework. And then building our action plans around how are we going to see that displayed when we go back and we check. So having a process that you're going to go back and check each time and identifying what does that look like? How are we going to know that we see that these things are moving forward? So I'm going to Judge Kerr talk about Mark.
Well, first of all, probably should explain, we are a 5-county circuit, and the counties are very, very different. Naples is very affluent, Fort Myers is a little less so, and also has some pockets that are different from other parts of it. Charlotte County is sort of like what Naples was like 30 years ago, a little bit more old Florida, and then Henry and Glades counties are very rural. There used to be sugar cane out there, so very, very different counties. We also are privatized in Florida, oh yay, and what that does is it's good in some ways, but it also chunks everything up. So DCF, which is Department of Children and Families, basically is the arm that has the attorneys as well as the investigators. And then the case managers are under a private nonprofit corporation. We have 2 case management organizations in the 5-county area. They're all under Children's Network, which is where Karen is from. And then, of course, we have various service providers that they subcontract out. So there is a dependency judge in Collier, one in Lee, one in Charlotte, and then the county judges in Henry and Glades do the dependency there. They don't have that many cases. We also handle truancy court, dependency drug court, things like that. So it's sort of chunked up a little bit. In a couple of things that I wanted to mention. My first inclination when I saw this model was to bring it back and just sort of throw it at everybody and say, hey, isn't this great? Let's all go get in a room, all 500 of us or whatever there is, and all be exposed to this, and isn't this great? And Terry and what was it, Jen? I don't remember who it was on the phone, and they said, no, that's not the way to do it. So the first thing, I think it's probably depends on what the nature of your area is like. Just from the brief discussions we've had with the Virginia folks, it's a little bit different there. But for us, the most important part was to do this in layers. So the first thing we did was we brought together the leaders of all of the stakeholders in our organization and exposed them to it. And it was, we didn't have anybody that said, oh no, I don't like this, or I'm not going to do it. Everybody was just wow. And we had a couple of people that were just really sort of even overwhelmed and very emotional about it because they realized, wow, I wish I'd had this tool. I could have been making better decisions for kids. And so we did that first. The second thing we did was then have them come back and train the trainers. And then thirdly, we had them come back and do basically the goal setting, which Karen can tell you a little bit more about. I also had them do a special training for attorneys. Our DCF attorneys immediately got it. I mean, attorneys and judges sort of work in criteria and factors, so we think that way it's not such a big stretch for us. They got it immediately. They sort of started with it immediately. Everybody was trained immediately. Recently in February, we trained our parents' attorneys. And if you've heard Tim, I don't know if you've heard Tim talk, but he does a very good job of explaining how the model is really helpful to parents' attorneys, not only to making sure that the law is upheld and the law is applied properly, but also to vigorously defend and represent their clients. So that's really where we are at, and we're also at the point where we're now starting to check ourselves. Have we met the goals we said we were going to meet, and what are the next goals that we're going to try to meet? couple things I wanted to just make sure that, well, I'll say more later, but I'll let Karen talk about it. Karen is the trainer for all of the case management organizations and some of the investigative organizations too. So she's really very involved in that, and quite frankly, they're just taking it and running with it, and I don't actually have to be involved anymore. Initially, I was the one that was involved, saying, we gotta do this, and now they're just running with it, so it's great.
So part of our implementation strategy was really to get a good work group from each of the stakeholders together who had commitment to moving it forward. You know, as Judge Kerr said, there's 5 counties, there's lots of agencies, lots of people involved, but really what we wanted was a mixture of everybody who was going to come to the table, and didn't have to be the executives, but really needed to be somebody who had some decision-making capacity and some influence, and the passion to be able to bring that forth to the rest of their agency. And you all know who those people are within your own agencies. So it's really important to make sure that you select your work group carefully, because they really are going to be the ones that are going to go back and champion this cause. So we got everybody together. There was probably maybe 20, 25 of us from different areas, and we did another overview. And you'll find with this guide, for those of you who have had some exposure to it, and those of you who have had multiple exposures to it, every time you look through it, you find something different. It's more meaningful. You see something that perhaps you didn't see before, because now you have a case that makes good sense for. So it's interesting to see that it's kind of a living and breathing document, if you will, and multiple applications of the information that's available. So what we did was we got everybody together, we did another overview of what the focus was going to be, and then we spent the afternoon doing implementation planning and action planning, divided out by the groups to hold each other accountable to, you know, what are the attorneys going to do? What are the case managers going to do? What are the investigators going to do? Where is it within your practice that those critical junctures are that you're going to have some demonstrative evidence when we come back and look to see, yes, it's working here, it's working there. We had our diversion staff and prevention. So it was really interesting to collect all of the different action plans and put it together in a document and share it with each other of what the expectations are, not only in your own agency, but what are the other agencies holding themselves accountable to, and then what are we able to hold each other accountable to. So there's really no secrets. It's all out there on the table, and we know when things get written down, they tend to happen. So nobody wants to be the one that shows up to the party and didn't do what they said that they were going to do. So it's that innate, drive for competition and wanting to be successful that when you write it down, you're more likely to follow through. So we also are looking at that in reasonable, and we wanted people to have success with what they wrote down, so we encouraged them to, take those baby steps and really look at what can you accomplish in the next 90 days. Let's not be too far-reaching that people aren't feeling successful, especially with a new initiative. We wanted them to really identify what are just those key pieces that we can make a difference within the next 90 days. And then we started seeing things within our agency where, it started to trickle out, and people were going to court, and Judge Kerr was asking them the questions from the bench card, and some of them were freaking out, and some of them were, excited about saying, okay, well, here's where it's starting to come together. It isn't just another initiative. It really is a model of practice, and changing, it's not more work, it's just doing your work differently. It's looking at how are you more effective with your work, and family-centered practice, and family engagement, and all those things that we've been talking about for several years. It just kind of makes sense now and gives you a framework of how do you do that and what does it look like. So it's interesting to see where we've come, and we've taken some baby steps, and we've, you go down the hallway now and you see a laminated copy posted on the wall, and I had texted a picture of it to Jen when I saw it because I was really excited to see, wow, it's starting to catch on. And as it starts to catch on, and the more people talk about it, and the more excited people are getting, and the less scary it is. So it really is important when you're developing your work groups to have those people that are as excited about it as you are, so that they can go back and really, be that voice and show that passion and pull people in and help people see the benefits of moving forward in this direction.
Well, and to pick up on that, one of the things that I think is becoming very exciting is I'm really starting to see the benefits in court. I've had a couple of cases recently where the parents' attorneys that we got trained are asking these questions. And even though I determined that the children were dependent and that the parent was going to have to do a case plan, nevertheless, what it did for me, it gave me a deeper understanding of what the strengths of that parent were, and where we needed to focus the services for that parent and for that family, which I would not have had without that attorney asking these questions. The second thing it does for the court is it gives you the ability to make clear why the children are unsafe, or why this is a situation where the kids are dependent, or that the parental rights should be terminated. In our appellate district, we not frequently, but it seems like frequently, have our decisions overturned, which no judge really likes to do. And part of the reason is because they can't see the nexus between what's going on in the family and the child. And this gives me the tools to, first of all, listen for the evidence, but secondly, make the findings in the judgments that are necessary for the appellate court to see that there is a nexus. Domestic violence is one of sort of my pet peeves, because we've had our appellate court, Judge Fields was actually reversed. He terminated parental rights of a father who had killed the mother. Now, he didn't kill the mother in front of the child, so the appellate court didn't quite understand what the nexus was. But when you have these factors so that you can explain the surrounding, what's going on, it all becomes much clearer to the appellate court. So that really helps us not only do the right thing for the family, but also do the right thing for the children and have it upheld by the appellate court. A couple of things I wanted to leave you with, because I'm not sure how much time we have, but that were important. First of all, as Karen said, I probably heard this presentation now 6 or 7 times, and every time I get something different. But the most important thing I got in the last couple of times that I've heard this is the importance of bench card A. For me, I was very, very focused on the three-prong model and what factors were the basis of those. And what I found is if I focus on bench card A and getting that information, then all I have to do is take a step back, put the model over it, and it's very, very clear. So I think focusing on the 6 questions is very important, and it also helps the case managers too. The second thing I would say is get your judges and attorneys trained as soon as you possibly can. You can do it without having it judge-driven, but I think it's a lot more helpful if you do, because again, if it's not judge-driven, if you're giving the judge more information, the judge is going to appreciate it, I would think. So you can do it bottom-up or top-down, but I think it really helps to have the judges and lawyers on board too. For all those lawyers, I developed my own checklist, which was a little bit easier for me to deal with on the bench. What else? And I think that we're making better decisions. First of all, we're keeping kids in the home when we can, not in unsafe situations, but in situations where we can bring grandma in to be with the family, so we don't have to remove the children. One of the things that happens in our circuit is we can have kids from Collier County placed in Glades County, which is way out in the middle of the state. And as we know from the research, if parents aren't being able to spend time with the children, it decreases the possibility of permanency by 1/3 or 2/3, depending upon how often they get to visit. And a lot of our parents don't drive. So how are they going to get out to Glades County to visit with their kids? So if we can leave them in the home safely, with putting some safety precautions in the home, it really does help us. And also, being safety conscious, a lot of the organizations have sort of a procedure. We say, well, why can't the children be reunified? Well, this is our process. First we go to the supervised visitation, then we go to unsupervised visitation, then we go to this, and wait a minute, the kids are living in the home with mom and grandma, and we're giving mom unsupervised overnight visitation. Why don't we just reunify the children right now? So, some of these things become a lot clearer. And then, as I said, that's not just for keeping kids in the right beds. It's not that we're putting kids in unsafe situations. I'm much better able to see dangerous situations that I would not have seen before and make it stick in the appellate court. So I find this model extremely helpful. So I think that's it for me, and then Karen probably has something.
So for time, we're done.
Good afternoon. My name is Jay Duggar, and I'm a juvenile and domestic relations district court judge in Hampton, Virginia. And Melanie Galloway and I will talk to you about what we've been doing in Hampton. She is a child welfare supervisor at our Department of Social Services. We come at this with a pretty extensive history of doing systems reform work as a group. Hampton is I guess most people would say a small city. It's an urban jurisdiction, about 137,000 people. Demographically, it's about 50-50 black-white. We started doing systems reform work about 10 years ago. I've been the lead judge for those efforts throughout that time frame, and we've had very strong collaboration and leadership over the years. Before we got to this, we had done a whole lot of things that we were frankly very proud of. Back then we used to have 280 kids in care at any one time. Now we're in about 40 or 45, something like that. We haven't had any kids in residential treatment since 2007. We've structured a lot of things that really needed to be structured for reunification. And Lord knows we've created so many community services, community-based services in order to try to be able to do all these things. And we work together very well. But despite that, there was always kind of this thing that was missing in these cases. And what it really was, for me, it was really centered on information gathering and transmission to the court. And there were a few things that I would see in these cases as a sitting judge that concerned me. One was that we always, and this is all of us, but certainly the workers, and I think all of us in the legal community, we kind of dealt with these cases when we talk about the reunification side of things. We dealt with them in kind of a recipe fashion. We, the system, have your children. If you do A, B, C, D, and E, then you can have them back. But if you're missing one of those, then we're going to go to termination, regardless of whether they would have been safe or not. That's not the issue. If they weren't safe when we took them from you. And if you get these things done, you're good to go. Maybe we'll change those things up and add some things to them. But it was very much that kind of an approach. And for me, that was always a little bit uncomfortable, because there wasn't always the connection that there needed to be between those services, really, and the safety of the child. And we had a few cases that, they kind of brought about that thought for me and for others. There was also always kind of a little bit of a lack of structure on the front end. One of the things that happened with us is as we moved towards ongoing services on the front end of these cases and away from notions of removing children from their families, a lot more of this work ended up being done on the front end of the Department of Social Services. Many of those cases never came to court anymore. They may not have even been child protective order cases. And there was always this question about, well, what's the structure behind all that? How is all of that working? And what is kind of the oversight and transparency, and how do we deal with all that? We had all of that going on. And everybody wants to take credit when you have a great idea like this, So who got into Hampton? I will say this: we had multiple people that saw this at almost the identical time frame, partially because our CIP director in Virginia had Terry and Jen around the state blanketing in place with information. So she had asked me to attend a guardian ad litem training because she wanted to put this before all the judges at the judicial conference. So I had seen it there. And then I had taken it back to some of the leadership people at the agency, and they said, well, we've already got that. We got this at the AFSA training, I think, or something. And so they had already seen the book. And so we really started talking about it at that time. After that, Jen and Terry came and presented again at the judicial conference. I've now seen this, like the other judge here, I've seen it a multitude of times. And it's always great. You always do get something new out of it. But what I really loved about this system was that it provided a degree of structure in an area that really doesn't have it. When we talk about notions of safety, I think all too often we all kind of in the legal world, we talk about it's almost like a Supreme Court case on pornography. I don't know how to define it, but I know what it looks like when I see it, right? And so when we talk about an unsafe child, you know, we didn't have any real concrete criteria to it really when you were making your decisions. You looked at the overall situation and then you said they're unsafe. Why? Well, look at the facts, right? It's very fact specific. There's still a great deal of that, obviously. These are case-by-case situations. But one of the things I really love about this is that it really provides, we use the word structure, a framework of thinking your way through these things. It's really helpful. It's helpful for everybody. It's helpful for the lawyers. It's helpful for judges. It's really helpful for social workers and other people that are working for these families, and then to bring that evidence to the court. And it really is kind of a unifying thing. I always looked at this and said, well, it's a guide for judges and attorneys, and so what it's really about is making sure that judges and lawyers beat the social workers over the head with it until they do this. Fortunately, in my jurisdiction, it's not. I mean, it's very much, this has been something that as we've begun implementation, and we said we would be fully implemented, which means everybody said they'd start playing by these rules beginning April 1st. So we continue to train a lot of people. We've already trained all of our lawyers and a bunch of other people, and we continue to train all the other agencies that we deal with, partially because one of the things that's great about this is the information issue. And what I love about it is that they talk about information in a different way. The perfect example, I forget if it was Terry or Jen used, but is talking about mental health issues with somebody. It's not about whether mom is bipolar. What matters is how does that reflect in their household? How does that affect this particular family, this particular child? And what do you need to do in order to kind of work with that, both on the safety side, separate and apart from the treatment side of things? And separating that treatment plan and safety plan, I think, is very, very different from the normal practice of most agencies and most legal systems, frankly. You know, as we talk about that recipe kind of approach. So we come from a history of collaboration that's really good, and it's really been helpful for us. And I tell you what's really been helpful is that our DSS has really run with this, and they're doing some really great stuff. What's going to be interesting where we are right now is very early. So I'll tell you the challenge is that we can all change structures and we can do other things. Getting people to change the way they think about these things is a far more challenging issue. You know, I've always felt that people kind of do things the way they've always done them. And that's the hardest thing is to get somebody to change the way they think about the issue of safety or planning for family reunification and so forth. But we got a lot of people that are working real hard on it, and I will let Melanie talk to you about what we're doing implementation-wise, and she has some of the things that we've created that hopefully will help move that along.
All right, thank you. What I would do is give you the nuts and bolts of how we got where we are. But I wanted to backtrack a little bit about what Judge Duggar said. We have moved at lightning speed. We just had our first training January 13th of 2012, and we've implemented effective April 1. So when you say we are the Energizer Bunny, that is us. We are rocking and rolling, and we're moving very swiftly and quickly. So we have done a lot of legwork in a very, very little amount of time. But what they came in January, then we turned around and had an in-house training for all of our staff, and that occurred in February. And also in February, we also did a train the trainers to our community partners, which was a little bit of an adapted training of what the child safety guide was. More about what's the definition of abuse and neglect. Really, people understanding what is child. Our focus more than necessarily on the Child Protective Services side, even though it goes all across the child welfare spectrum. So our main focus, is over on the Child Protective Service side of the house, and then it just naturally flows through every part of child welfare. So we are now training. What we did, we had to train the trainers. We had a lot of our leaders from our community partners, our mental health, our schools, our civic groups. You name it, they were there, a lot of our stakeholders. We are a very collaborative city, so it's very easy for us to pull people together. If we can't get them, we call the big guns in and we get them together. But there really is a true sense of collaboration in our locality, so it was very easy to get everybody on board. So what we did with our train the trainers was we're now linking a DSS person with that lead person of the school, with the lead person of the court service unit, and they're going and training their staff. So we have what we call a big, hairy, audacious goal, and by next year, 2013, everybody in our city will be educated on child safety. So it is and as fast as we're moving now, we truly believe we will get that goal accomplished. So after the trainers, of course, we did another training to our staff or anybody who had missed the training. And then, as the judge said, we trained all of our attorneys to include our Commonwealth, our own city attorneys, anybody who touches our children in our dependency court was held in March. And so far, we've trained over 340, 350 people so far. And we're still counting, but we're not just doing community, we're going beyond community partners. We've had staff go to the churches, we've had people go out to the deltas, we've had people in the sorority, anybody who's asked and want information about child safety, we're going and doing it. So we've just made a dedication. We have the leadership at our agency. Just like Florida said, it starts from the top down. Yes? Yes. What do you mean? Oh, I talk really fast, so please forgive me. See, time to slow down. Our schools, we partnered. We have DSS staff that partnered. We started with our school social work staff. They're trained, and now they'll be partnered with a DSS person, and then they train their own people, and our goal is to have every one of our schools trained, including anybody who may interact with a child, down to your janitorial staff, all the way up to your principals. So when they have their teacher work days or something, we're going to be there, presenting to them. So we have really taken on a whole lot, and we're very excited and very enthusiastic, and we're ready to go with that. They've actually embraced it, and part of that is because they're a part of it. Once we train them, they're our partners, and they're just as responsible for getting this information out. So, how we, and I have a lovely Vanna White with me down here at the bottom. So when you talk about our strategies to implementation, we created what we call the Child Safety Implementation Team. After they came down, we had our meeting, we had our managerial staff, our supervisory staff, as well as our senior workers, our principal workers came together and said, now how are we going to make this happen? And because we all, believe it or not, are this enthusiastic, we really are at our agency, everybody just took a piece, we divided it up, and we made it happen. So we actually have our forms here to share with you. You just see as an example, so you can ask questions about how we're getting where we are so quickly. Well, Vanna, sure. We'll go ahead and pass them out really quickly just so you can see. The 6 questions are really what we train and we really want with our community partners as well as all of our staff as well as all of our city, that we're all talking the same language. So when I say to a school teacher, do you feel this child is vulnerable, they're going to know what a vulnerable child is. They're going to know what protective capacities are. We're all going to be speaking the same language. So we have talked the talk and now we're walking the walk. So they're going to be passing out information. And our staff have the 6 questions with them everywhere they go. Those 6 questions are now embedded everywhere in all parts of, sorry about that, in all parts of our child welfare system. When our child protective service workers go out and they're doing their investigations or assessments, they're going to be asking those 6 questions. We're asking those 6 questions even with our foster care kids and when we're going to court. We also changed the way we write our court report. We have a new template. You'll be seeing it as it comes around. We've actually adapted the 6 questions and made it into a court report. And what we found was a lot of the stuff we were already doing is just the way you word it in your language. And it really was rather easy to put together, and that's how it moved so quickly. We kind of jumped the gun a little bit. We decided that Judge Duggar and we would implement April 1, but because we are fast movers, we internally implemented in March. Because you all know there's going to be kinks, there's going to be bumps, there's going to be who knows what's going to happen. So we implemented a little bit early, and we actually started submitting this stuff before, and he got it kind of before it was really 100% in place. But it also compared our attorneys and things like that. The main thing really, we have the community buy-in, we have the stakeholder buy-in, but it is also a paradigm shift in the way that the workers do their work. the way that you do business. It's not the way your investigations, you can't go out there in 5 minutes and say this is a safe kid and walk away. You're going to have to come back with all this documentation. You need to do a thorough assessment to just say, not to just say they're safe. Well, the kid was wandering at 3 in the morning in the street, but by the time I got out there, mom was back, so he's safe. That's not good enough. We need a little bit more information. We need a better assessment. And if you follow these 6 questions, you can get a world of information. So really quickly, I'll talk about, we need to change the way we do safety plans. So the big long sheet that you see, everything that's in your child safety guide, threats of danger, safety factors, vulnerability, all of that is language that we're now using, and it's driving what our safety plans will look like. We went as far as to make sure there's a difference between if it's an in-home safety plan, if it's an out-of-home safety plan. And in Virginia, we use family partnership meetings, family engagement meetings, and that has to be scheduled if you place a child out of the home within 24 to 48 hours. So as you can tell, we are moving very fast, but we have been seeing some great results. A great example I can give you is I'm reading a Child Protective Service investigation that's ready for closure, and in the summary, it was so good, and it hit all 6 of those questions. I really thought another worker wrote it. It was that good, because they were able to assess. It's the truth, because once you have a framework and a guideline to go from, and you're answering those questions, I can honestly say this child is safe. We have put in the most appropriate services, and we can close this case. Our evaluation efforts, our outcomes, we have a continuous quality improvement unit staff that will be looking at all of our, from April 1, where are we going. They're also going to be coming in and giving, we're going to be meeting with Therese and them about getting our baseline data. So we're going to start our April 1, looking at all the cases through when they come in June. We also will be tracking in Virginia, we have the Safe Measures system, we use that as well, but our continuous quality improvement unit will really be behind reviewing those cases, and are we really truly doing what we're saying we're doing. So that's Hampton.
Let me just say one other thing. I think the best thing about this system really is that what it gives you as a decision maker is a little bit more comfort. It's a trying area of law and problem solving because there's so much danger involved. And so many places I see decisions being made, it's really kind of a better safe than sorry kind of notion. Jen's talked about that in some of the trainings. You know, and that's not why any of us should be making decisions. You know, we should be making decisions because it's the best decision for the child and for the family. But everybody's so scared because they don't have the right information. They'd rather be safe than sorry. And quite often we forget that you think it's safe and sorry when you remove a child and place them with some strangers that happen to be good folks, and we forget how much damage that does to children. And so either way, we're damaging children potentially. And so what we need to do is we need to be able to control and make good risk evaluations and safety evaluations for kids. And the way this is structured for information gathering to give us complete and thorough and information with depth to it really puts judges and attorneys and social workers in a position where they can really make the best decisions possible at each decision-making point. You know, the information changes. You know, at the original removal hearing, they don't have everything together that they're going to have for me at the dispositional hearing or at a foster care review. But they're constantly gathering that information. And having really good information makes everybody better at their job. And having a kind of structured way to think your way through this is really helpful as well.
Great. Before we open it up to questions and answers, how about a round of applause for both of the judges said. We gave you the talking points, but really, you know, on a panel like this, you don't know exactly how it's going to go, right? And both of the judges talked about the importance of the information collection, and I was a slow learner too. And I think those of us in the legal field are, just as Judge Creer said, so eager and excited to get, well, give me the criteria, give me the, what are the elements, you know, so that I can apply the facts. Forgetting about how important the fact gathering is, and that oftentimes we make decisions cases on very, very limited information, and we're missing a whole world of information that's relevant to family functioning. So I just love that both of the judges, without me knowing, would make that point. So that's great. So we actually kept to our timeline, like to a T. It was amazing. And we intentionally left 30 minutes for a question and answer because really this is an exploration of how do you implement the safety guide. So I'm going to open up the floor for questions for the panelists or for myself, Timothy, Terry, about anything that you've heard so far, maybe something that you wanted to have answered that you came to this session for and didn't get answered that you'd like to answer. So I'm going to open up the floor at this point. Yes, Sarah. How do you do? And maybe, how about this also, if you can say where you're from and what your role is, that would be helpful. Thanks.
My name is Sarah Boswell, and I'm the Family Court Liaison in the Kentucky Administrative Office of Courts. And Kentucky has a unified court system, and we work with our courts pretty much on a statewide basis. And I guess my question is, did in any of the projects that you have, I realize that you represent your jurisdiction and you are doing that locally, and we do those, of course, locally too, but we provide a lot of technical assistance and a lot of support to our local courts in efforts like this. And did you all have that kind of assistance from a sister agency, one much like ours, or anything like ours?
Do you mean like the
State
court
level.
improvement? Yeah, okay, that's an excellent question.
Yeah, we coordinate the court improvement program grant also from that centralized from AFC. And
That's-
every state's got, like, a lot of states have administrative officers in the court that provide some technical assistance and support. And I'm just wondering if you all had that.
Yes.
It's a terrific question, and I know Judge Cruz chomping a bit, and I haven't been out of the courtroom long enough to know I'm never 2 sentences away from contempt, but let me go first on that. And I'm so glad you said that, Sarah, is that how you access our training and technical assistance is either through your court improvement project, and all states have it, as Sarah indicated, or your child welfare agency. And so I'm going to say probably 99% of requests for the safety guide come through CIP, which is the acronym of the Court Improvement Project. So if you hear something you like here, talk to us, and the first step would be to contact your CIP person as a point person. I'll say one more thing, and then I'm going to turn it over to the panel. Is that it's our hope that the court improvement folks play a greater role than simply making the request of the regional office, because we need to get all that approval in place before we can come out and provide the free training and technical assistance. And they're very good managers and handling that. But it's our hope that the CIP projects around the country will also have a level of sophistication and understanding what this is, and so that they can do more than simply set up phone calls and get the training site and that sort of thing, and then they can actually help drive these initiatives, because as Timothy said so well, I think that we come in and provide the TA, but we're not doing the work, we're not managing it. And so CIP could perform a role where they can help manage the implementation of the strategic plans that get developed. So I'm going to stop talking and turn it over to, if anyone on the panel has a comment about the role of CIP and the support that they receive from them.
Well, in Florida, we had a court improvement panel. I'm on the panel, it's a statewide panel. We also have an Office of State Court Administration, and one of the things that's made this so easy is that I came back from a conference and literally picked up the phone and I think called Terry and said, hey, we'd really like you to come down and do this, and then they hooked me up with our liaison person with the Office of Court Improvement, and they pretty much do, I mean, anybody that's ever done a seminar or a workshop, it's a lot of work, and they did 90% of it. As well as, the fact that it's free is really makes it a lot easier too. But in our state, because probably along with everybody else here, we all flunked our federal review a couple of years ago, they are very intent on improving the dependency court system. So we get a lot of assistance from them with that regard. So it makes it really easy. It's sort of like surfing, on top of the waves. So.
I guess my answer would be maybe a little, and I don't know. Our effort has been completely locally driven, and so what we're doing is completely locally driven. We really came into contact, as I said before, with the guide I came into contact directly as a byproduct of our court improvement program. Our director of the court improvement program specifically asked me to go because we've been kind of a leader in this area in Virginia for a long time. So I went to a guardian ad litem training that they were doing all day and sat in on it. That's how I came into contact with it. So that degree certainly had something to do with it. What I don't know is whether CIP has funded anything as far as them coming to our jurisdiction at all. But otherwise, we were completely locally drawn to it. We loved it. And I talked to Terry at the judicial conference, and Shirley called them, and so it's all been locally driven, and really has not had any contact with CIP other than them asking us, hey, how's everything going down there? Because they know that we'll run with it.
Let me just add that, as I said in my overview of the change model, we want involvement from the state level, even though these projects are done on the local level. And the reason for that is there are, how many judicial districts are there in Florida? I love Florida, but I don't want to go to 20 judicial districts in Florida to do this work. Eventually, I want the state of Florida to have the capacity, working with the communities that have already done this and working with the state CIP to get this done everywhere. Because one thing that happens is something good is going on next door, and people are looking over and going, how's your grass look so green? And the next thing you know, they want this to happen. I'd be pleased to go to 5 maybe places in Florida, especially if it's not in the summer. But really, we want to get your capacity to the place that you can do this for yourself, because you can do this for yourself. And the CIP is a big part of developing that capacity.
As is the Child Welfare State Office, and I gotta say, my brothers and sisters in the Child Welfare State Offices have not been at very many tables. So what we like to see is that CIP and State Office Child Welfare staff would be coming together to do the same sort of the demonstration of the two roles that you see here that we supply through consultation, is that's the way that we could really help a community who wants to implement this move forward faster. To say a shout out to Wisconsin is that we're, Timothy and I are coming to do an overview for an exploratory group in early May, and that request came from CIP and Child Welfare.
That's why I said 99%. I saw a gentleman from Wisconsin, and I remembered that as being the sole exception so far. Right.
Cutting edge.
Yeah, cutting edge, right up here in the front row. Other questions? Please.
I'm Gateway Coyle with the Child Abuse, and my question is, another court model that's being showcased in this conference is the 0 to 3 court model. Are you aware of any court that has implemented this model and that model? They work together?
It's great. It's my understanding, Judge Greer, that 0 to 3 originated in Florida in Miami-Dade, right, and with Judge Lederman. So I'm going to punt that one to you. Let me say this. I am quite familiar with the model, at least the one that Judge Lederman created, the 0 under the rubric of 0 to 3. And philosophically, we're lined up and completely. Now, has there been a formal, I'm turning to Florida because it originated there. I don't know.
Well, if what you're talking about is the 0 to 3 parenting model, is that what you're talking about?
I'm talking about the 0 to 3 court model.
I'm sorry.
Court model.
Oh, right. Serving babies to the bench. Well, that's primarily a hands-on parenting model is what it is, being focused on making sure that that the parents and or parent are hands-on receiving training and counseling about how to interact with the children, as well as making sure that the children from 0 to 3 are focused on in terms of developmentally. And I know Judge Lederman pretty well. That's sort of what her focus has been and the focus of that program. I don't know whether that's exactly what you're talking about, but
It doesn't sound quite the same. It's,
you're talking about, did you see the video?
no, I saw a presentation here yesterday afternoon.
It's the 0 to 3 that has the W's and the capacities.
Yeah.
this to make that work. Because one of the things that, this information gathering, this decision making keeps you from dithering. One of the reasons the cases remain open for so long is that we don't know what to do because we don't know what to do. And what this particular approach does is that it cuts to the chase because it says this is what you do, this is what you gather, and this is what you look for. And one of the things about when you come to a conference like this, and you see, I listen to a trauma-based presentation, and that doesn't conflict with this. Trauma-based analysis happens within the information gathering that gets applied to the decision making. Domestic violence, substance abuse, it's all part of the information gathering that bears on the decision making. So it's not in conflict with any of these wonderful approaches to child welfare.
Well, and as Terry, I think, has said on the 5 or 6 times that I've seen her say this, is that this model is based on the models that are prevalent and that we know already exist in the child welfare system. And you can see it because you see commonalities in systems like that. You see commonalities, well, not just commonalities, but almost the same in structured decision making. I mean, it's time tested. I'm not sure you call it evidence-based, but it's time tested informational points that we're all aware of. And so it's not just sort of intersecting. It is that because this is what that's based on. So does that sort of answer your question, Jimmy?
I think too, from what I understand of that model, and they may use different terminology, but the concepts, and as I was saying, philosophically, they're consistent about the enhancement of the protective capacities, which is the whole idea of, it's not that we need to completely eliminate the threats that are present, but we need to reduce the threats that are present at the same time that we're enhancing the protective capacity. And obviously, I mean, we used to call it strengths, but strengths, I think, is not quite the right word, because when we say strengths, people think, does mom have a job, or, does grandma live down the street, or is there, an extended network of support? And we don't not mean that, but we mean so much more than that when we talk about protective capacities. And I love, I was looking at the handouts that I just got before the session about how you really flesh out what we mean by protective capacities and protective characteristics. And in that model, with the intensive front-loading of the services to work with the parent, that the family, and it ties into well-being too. I get so excited, and I know it's a little long-winded, but Terry and I just had a meeting with some of the feds, and we talked about, this is really about well-being and permanency too, guys. And that as we're working on protective capacities, we're enhancing the well-being of the family, which is exactly what that model is. So does that help answer your question?
It does. So let me just ask a short follow-up. Does it support the idea of concurrent plans?
Absolutely. Yeah. Absolutely.
So they probably would actually put there.
You have a better informed decision about the need for a concurrent plan, what that would be.
As Timothy said, I mean, when you have this, when you use this model, you can see more specifically what's an issue for the family. So rather than applying a whole bunch of services that may or may not really have an effect on people, you really can target in on what needs to happen in order for these people to be reunified or to have a much more meaningful relationship. And you're not wasting a lot of time. So therefore, you can move to permanency quicker. And if you can't, then you know pretty quickly, and you can start planning for alternatives. So I think it just gives you that much more specificity.
And I just wanted to add to that I know there's a lot of different models that are out there and different framework and things like that. And as Jen had said, a lot of them, they do overlap together and have a lot of the same core basic concepts. And what's really critical, I think, for your frontline staff when you're thinking about implementation for this piece is really understanding that it's a skill set that you're helping them develop. And when you can develop a skill set of doing good, solid assessments and looking at what is that underlying cause, not just what's on the surface, but what's behind it, and that holistic approach, you can take that skill set and apply it to most of the models that are out there, or whatever tool happens to be the next one that's on your desk. You really have to back it out to what are the basic core principles and what are those core competencies that we need our staff to really develop so that they they can make good assessments and make the right decisions at the right time to influence what our outcomes are.
Point, Karen, thanks.
I think your question really has a lot to do with whether implementing this somehow affects your implementation of other things. And Lord knows we've had enough going on over the years. This doesn't affect any of that. In fact, it enhances it quite a bit. Really, a lot of the decisions that we make, it doesn't matter if you've got a concurrent plan. I mean, you're talking about having the right information to make the decision at the right decision point. It's, regardless of how you're doing it. And when we talk about reaching permanency faster, if we're just talking about reunification, the notion of reunifying the family, when you can isolate that decision to issues of child safety and separate out kind of that old laundry list kind of thing where our treatment plan issues, we're going to continue to work on those, maybe with a child protective order after reunification, then you really do speed up that reunification. The thought process is quite a bit different there, and you're going to bring about a quicker reunification of the family, at least as far as the child being home while services continue. And certainly if we talk about services continuing while there's a hands-on situation, then the best place to have that is with the family together.
Other questions, please?
I was here yesterday, and so I'm just wondering if the state drive has the 26 states were implementing this model and your presentations on the state drive?
Yes, on your stick drive, if you go to the third to the last slide, you will see a map of the country, and it's color-coded. And so you'll see where we've been. It's a little bit, someone just asked me in this meeting I referenced, well, how many states are implementing the guides? So you can't even really answer that question because in some of the states, they really just had the overview. And then you've got the 2 states to my left that, in our opinion, are the furthest along in terms of implementation. So with that caveat, the answer to your question is on your stick drive. And listen, you've got contact information too in there, our email addresses. So if you have more specific questions about what might or might not have been happening in your state, ask us. Other questions? Dr. Campy.
So, as a researcher in the room, my question is about outcomes. So, you guys are kind of early in the process. How would you know if you have been successful? What data, what outcomes are you going to collect at some point to see if it's making a difference?
We have evaluated both the outcomes versus outputs personally. Is developing the logic model.
Good thing you got the mic just in time to say a logic model.
I don't even know what logic is, but we have a logic model that is in development. And so I think that right now, what we're concerned about, and what the evaluation of these sites is concerned about, is outputs. It's concerned about developing skill with the process so that we can say, before we say, is this method making a difference here, we can say, we're doing this method.
Yeah.
Okay, so right now we're worried about the validity and the fidelity to the process. And then our certified smart evaluation person is going to tell us which of the many wonderful goals in the world we're accomplishing. So that's where we are. This is very much a work in progress. These are our pioneers. They are blazing the trail in implementation of the Child Safety Guide.
And I can also add for outcomes, Virginia, we're now becoming a very outcome-driven state, and there are critical outcomes that we're already measuring that are statewide as well as locally we measure, and we're really be crossing a lot of that, all different kinds of data. Was there maltreatment? Was there re-entry into foster care? Were they removed from the home? And we're going to be tracking all of that in tandem with all the outcomes that they'll be doing. And more focusing on, did we make, not necessarily was it the right decision, were these children safe? Where are we at? And, we actually, one of our core values is we start with the outcomes and not the process. So, you've got your, so we're already there, we're already driving. We have a unit that's specifically set up to help make that happen. And through our quality service reviews that our state has also embraced looking at it. So we have a bunch of different methods that we'll be able to pull from to get great outcomes, and the super smart people from the child safety will be there too.
Other questions, please?
there's this language being packed at that point. So I feel confident that the cases that are coming into the system that are being filed in the court are the ones that have this framework. But then the law uses another set of language, and so we just use that language in court. And I guess my question is, I'm having a hard time wondering what the judges actually ask that have to do with the safety. Is there impending danger? Are you asking those kind of questions, or is it more helpful on the back end, getting the kids back home?
I think it's helpful on both. Actually, Jen does a really good job, and I think it's in the book there, talking about kind of that issue. Because, different states have different language that's all consistent with the Adoption Safe Families Act and all that. And we all use, kind of nuanced different language. But really, it's all about these core issues. And so there's no reason to talk about anything other than the child's safety and whether the child is safe in the home and so forth. And you can make the legal findings and still have those discussions. It may be appropriate to use the technical term in your ruling. And clearly, the orders have to be done consistent with your individual state law and federal law. But the discussions that you're having and the evidence that's being presented and so forth, having it presented in this context doesn't change that at all. Because we're really always talking about the same types of issues. One of the good things about this area of law, frankly, is that I can sit here with this nice judge from Florida and we can talk about this. If we were talking about something else in law, we'd be sitting here looking at each other like kind of strange. We're going, you do that? What does that mean? That's not what we do in Virginia. That's not even close to what our statute says. But all of this, there's a fair amount of uniformity, at least in child dependency cases throughout the country. So you can really, in this area, I think you can, because the core concepts of what we're talking about with child protection, whether we're talking about court involvement or social work or whatever, because all that's really the same. And it's no different where I sit in Hampton than it is in Florida or California. We, the court, is an oversight agency, and our job is to review what's going on with cases to ensure that the agency is doing what they're supposed to do. And we try to, I think if your jurisdiction works well, everybody's supposed to be working together to bring about the positive result. And I don't see any real conflict at all with that. I mean, I think that sometimes I have lawyers use all the wrong language anyway. But as long as we're all talking about the same core issues that are the basis of your decision making as a judge, as a social worker, as a lawyer that's arguing, as a guardian ad litem that's arguing, it really doesn't matter that much. That's not the issue. And one thing I do like in the book is that they go out of their way in their presentations to say, look, you can say it however you want, contrary to the welfare of the child, whatever language you have in your statute. But what we're all talking about is the child's not safe, where the child is safe. And so I don't see that as being problematic at all.
Well, and what I do, as I said, the law in Florida is pretty vague in terms of there's really not a lot of specificity to it other than like some really obvious things. And so what I do is I'll say something along the lines of, there's a preponderance of evidence that the child is abused, and then I just launch into these factors. And I really list to go down the headings to do it, just that way. It's just like findings of fact.
They're kind of sub-findings. I mean, you put the findings you need in law, and then you're going down the factors.
Correct. That's what I mean, again, if I'm making a finding that there's preponderance of evidence that the child is going to be or has been abused, then I literally am going, okay, this was the danger, this was the harm. The child had, old bruises and new bruises and old breaks and new breaks, and I just go right down the thing. They don't need to know, they don't need to know, the appellate court doesn't need to know that I'm using the safety planning model. What they're going to know is I'm making very specific findings that relate to, as the judge said, the safety of children. I think you can use any language you want to use, and you're just making findings about this stuff.
And if you look at their 6, then when we talk about abuse or neglect, you're talking about nature and extent of maltreatment.
Exactly.
So, yeah, I mean, there's a direct crossover regardless of the terminology that I think you use in pretty much any state.
Yes, please.
I'm going to ask an apple and oranges type question to push the frontier to a different place. A really hard place for these children is to be in highly contested custody cases, not necessarily in the welfare system. Is there any part of this framework that would be useful in those kind of cases?
Yes. I was a family law attorney for 20 years before I went on the bench, and I'm just actually going back into family law. I'm going to be doing dependency and family law starting July 1. And a lot of my parents' attorneys are also family law attorneys. And I see a lot of crossover with this. You know, in family law, people get all excited. Dad can't have time with the child because dad's smoking marijuana. Okay, well, dad's smoking marijuana, and that's not a good thing, but is DCF in the picture? I mean, what is the connection to the harm? What's the maltreatment? Are the children vulnerable? Is he driving around with the kids in the car while he's smoking pot? I mean, what's going on? I think this is absolutely useful in family law. And that's going to be sort of my next project when I have some time, is to start educating the family law bar a little bit more about these things, because I think it clarifies really when we need to be worried if we're worried, and what can we do to strengthen the family so that both parents can have as much time as possible, or the children can have as much time as possible with the parents in a safe environment. Because that's really the goal in family.
And really quickly, in contested custodies, or when there's home studies ordered, and this is where we were saying earlier that this can cross the complete spectrum of child welfare. So we have a core service unit that does just the home studies. So what we're cross-training them to do is the same court report format. However, they're not going to have a nature and extent of maltreatment or circumstances surrounding maltreatment, but they sure can answer how the child functions day to day, what's the parent's form of disciplining, what's the overall parenting practices, and that will give you such a sound report also that you can have an independent court report home study submitted to the judges to be able to make decisions.
That's great. Thank you. I take the panelists on the road with us. It's so great. You get tired of saying the same thing. You try to say it different ways creatively, and then, my gosh, it's been wonderful. Are there any other questions? Okay, so thanks again for your participation. It is 5:30 on Thursday, and I really appreciate it.